Hello everyone and welcome back to our channel. My name is Anda Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. Today we are going to speak about the key characteristics for obtaining your green card through consular processing. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. Now, the avenue through which you decide to obtain your green card, whether it is through adjustment of status or through consular processing, it leads you to the same destination, meaning that whether you are going to obtain your green card through adjustment of status or through consular processing, you will ultimately obtain the same thing, your green card, your permanent residence in the United States. Now, there is no one-size-fits-all solution for how to obtain the green card in terms of whether you should do adjustment of status or you should do consular processing in order to obtain your permanent residency. Instead, it depends on your personal circumstances whether you will be able to apply for adjustment of status or consular processing. And in certain cases, consular processing may be the only option available to you. Now, before you even reach the level of deciding whether you will be applying for adjustment of status or consular processing, you need to have the underlying basis for your green card approved. And this means in family-based cases, your Form I-130 approved. And in employment-based cases, it means Form I-140 approved. For special immigrants, it means Form I-360 approved. And then for those investors who are obtaining their green cards through the EB-5 Immigrant Investor Program, it means Form I-526 or I-526E approved. So you need to have one of these forms approved based on your category that you are applying under, your basis for the green card, before you can consider whether you will be obtaining your green card through adjustment of status or through consular processing. In this video, we are going to speak about the key characteristics for obtaining your green card through consular processing. The key characteristics of obtaining your green card through consular processing are: 1. Shorter processing times. One of the main advantages of the consular processing is that with consular processing, the processing times are much shorter when compared with the adjustment of status processing times. And also the immigrant visa numbers become available faster with the consular processing when you compare it with the adjustment of status. And that is obviously in general. Now, with consular processing, your USCIS approved petition will be forwarded to the National Visa Center and after to the US Consulate, where you will have your interview. 2. Interview is required at US consulates abroad, and there is a potential for inconvenience and costs. Now, with consular processing and obtaining your green card through consular processing, you are required to attend an in-person interview at the US consulate abroad for your immigrant visa interview. You have to appear for the interview, and US consulates do not waive the interview requirement. This is unlike with the United States Citizenship and Immigration Services and obtaining your green card through adjustment of status, where the United States Citizenship and Immigration Services can waive the interview requirement, so you are able to obtain your permanent residency without attending an in-person interview at the USCIS offices in order to adjudicate that adjustment of status. Now, For those of you that are already working and living in the United States, traveling to the US consulate abroad in order to attend an in-person interview for an immigrant visa may be inconvenient, and also you will have additional expenses for the traveling accommodation and anything else in between when you travel abroad to the US consulate in order to attend this interview. And also keep in mind, US consulates schedule the interviews at a date and time that is favorable to the consulate without taking into consideration your personal schedule or your employment situation. So, of course, traveling abroad for those of you living in the United States may be inconvenient and may disrupt your personal schedule and your family schedule. And that is separate from also the expense of having your family travel abroad for the immigrant visa interview with you. Now, for those of you who are not working in the United States and you are not living in the United States, and the only way to obtain your green card is through consular processing, and you live in your home country, then the consular processing is not as inconvenient to you as it is to those that are living in the United States, because you already live in your country and you can more easily adjust your personal schedule to accommodate the immigrant visa interview, and also the travels to the interview, if you don't live in the same city where the US consulate is, it's much smaller distances than traveling all the way from the United States in order to attend the immigrant visa interview. So definitely for those of you who are not living in the United States, consular processing does not present the same level of inconvenience as those living in the United States. And now attorneys typically with US consulates abroad are not allowed to attend the immigrant visa interview with their clients. With the adjustment of status through the United States Citizenship and Immigration Services, attorneys may attend the adjustment interview at times. 3. Documentary requirements. So consular processing has stricter documentary requirements when compared with the adjustment of status. With consular processing, you will be asked to collect a large number of documents for the US consulate. So every individual who is applying for an immigrant visa, the US consulate abroad will need to provide a number of documents, including valid passport, civil documents such as birth certificates, marriage licenses, death certificates, divorce decrees, and police reports as well, and a medical exam from a US consulate approved physician. Now, the police certificates, the US consulates abroad will ask you to obtain police certificates from your country and your country of residence if you've lived there more than 6 months, if that is not your home country, and also the police certificates from every country you lived in for 1 year or more since the age of 16. So if you have lived in multiple countries since you've turned 16 years old, then you will need to obtain a large number of these police certificates, because you will need to obtain police certificates from each of these countries. And then you also have to take into consideration that sometimes the process of obtaining these police certificates in that specific country where you lived may be burdensome, in the sense that you may be required to travel to that country in order to obtain the police certificates, the police reports that the US consulate will need in order to process your immigrant visa. Now, with the medical exam, you will be required also to attend a medical exam with the US consulate approved physician. And each family member will have to do the medical exam if they are applying for the immigrant visa. 4. No work authorization or travel document while the immigrant visa is processing. So individuals who are applying for the immigrant visa through consular processing will not be able to obtain a work permit or travel document while their visa is processing. Of course, this is more important to those of you who actually live already in the United States. Those of you who don't live in the United States, this is not relevant for you. But for those of you who live in the United States, the fact that you cannot obtain a work permit and a travel document while the immigrant visa is processing can be quite inconvenient, especially if you have spouses who are in status that does not allow them to work in the United States. So for example, if your spouse is in H4 status or TD status or O3 status and they are not allowed to work in the United States and you are consular processing your immigrant visa, then they will not be able to obtain a work permit or a travel document, but especially the work permit in order to be able to work in the United States while they are immigrant visa is processing and you are invited for an interview at the US consulate. So until the immigrant visa is processed, they will not be allowed to work in the United States and obtain the work permit. Now, once the immigrant visa is processed, then you are invited for an interview and you have obtained your immigrant visa. Then once you come into the United States as a permanent resident, then you will be able to work freely in the United States. But until then, while the immigrant visa is processing, your spouse that is not allowed to work in the United States will not be able to obtain a work permit. And that is similar with the travel document as well, because applying for a work permit or a travel document is not available when you consular process your green card. You have to rely on your visa in order to be able to travel in and out of the United States, and you have to plan your international travel while your immigrant visa is processing, and at time exercise caution when it comes to traveling during the immigrant visa processing. And this is unlike with the adjustment of status and obtaining your green card through adjustment of status in the United States, where if you already live in the United States, you will be able to file for work permit and travel document at the time of filing for your adjustment of status. So if your spouse has a visa that does not allow them to work in the United States, then once they file for adjustment of status with work permit and travel document, they can obtain the travel document and the work permit prior to the adjustment of status being adjudicated, so they have the ability to work in the United States while the adjustment of status is pending and until they obtain the permanent residence. The same with the travel document. Once they have a travel document approved, then they can travel internationally while their adjustment of status is pending. However, you need to keep in mind that with the travel document, even if you have a travel document approved, once you travel internationally, it is not guaranteed that a U.S. Customs and Border Protection officer will admit you back into the United States. And finally, 5, no AC-21 portability for employment-based visa petitions. So for those of you who have an approved I-140 under employment-based categories EB1, EB2, or EB3, and you have an adjustment of status pending for more than 180 days, then if something happens to your job, meaning you are terminated and you need to find a new employer, or you are changing to a new employer, then you can you can transfer that approved I-140 to, and the adjustment based on that I-140 to the new employer, as long as your job is in the same or similar occupation as the original job offer. So as long as the new job is in the same or similar occupation as the initial job offer on which the permanent I-140 were approved, and your adjustment is pending for more than 180 days, then you are able to transfer that I-140 and adjustment to the new employer, okay, and obtain your green card without major changes to the process, in fact with no changes to the process. However, you will need to file for the portability if that is the case. If your adjustment is pending for more than 180 days and you have a new employer in the same or similar occupation as your initial and original approved job offer, then you will be able to notify USCIS and petition for the transfer, for the portability. Now, with consular processing, you do not have the portability advantage. So if there are major changes in your circumstances prior to the consular interview or after the consular interview, but prior to your admission to the United States as a permanent resident, such as you lose your job, then the perm-based I-140 may be rendered invalid and may not receive that immigrant visa in order to come to the United States as a permanent resident. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.